Ready? Start. We must also mention here that for the interest of the allottees, this court had made efforts at settlement till the last date of hearing. Stop. This court had indicated that for settlement, the petitioner should make an unconditional offer where he infuses funds into the project to carry out the necessary renovations as pointed out by the three reports, clear the dues raised by Uttar Pradesh State Industrial Development Authority for the execution of tripartite lease deeds with the allottees and unconditionally handover possession to the allottees. Stop. For this purpose, this court had also indicated that if such a proposal comes forth, it would implore upon the IRP to come on board, in the interest of the allottees. Stop. However, this court was informed that the above terms are not feasible for the petitioner. Stop. The petitioner proposed that he is willing to contribute an amount of rupees 5 crores. Stop. He further proposed that such an amount along with the amount already submitted before this court at the time of granting bail be used to settle all allottees who are before this court. Stop. However, the Invoice Registration Portal informed this court that such an amount is entirely insufficient as the total claims received are more than 1400 crores, with approximately 670 candidates. Stop. Creditors. As a result, the petitioner failed to arrive at an arrangement where the interest of all allottees would be taken care of. Stop. Also, the claims of the other creditors are more than 460 crores. Stop. Another issue that has been raised by the petitioner is that the present two-judge bench lacks the jurisdiction to modify or alter the orders clubbing the subject FIR dated 12/5/2022, as it was passed by a three-judge bench. Stop. While we are not delving into this issue in depth, as we are concerned with the cancellation of bail at this stage, however, we find reason to agree with the submission of Mr. Gopal Sankar Narayanan, learned senior counsel on this aspect. Stop. It has been submitted that on occasions, two-judge bench of this court have modified or altered three-judge bench decisions. Stop. We clarify that it is open for any party to move an appropriate application before this court on the issue of clubbing of FIR. Stop. Any such application, if so made, shall be decided on its own merits. Stop. The cumulative result of the above discussion is that the petitioner has not complied with the conditions of bail imposed upon him. Vide order dated 6/11/2019. Stop. Resultantly, the bail granted to the petitioner is cancelled. Stop. The petitioner to surrender within 1 week from the date of this judgment. Stop. Needless to add that any observations made hereinabove are only for the purpose of cancellation of bail. Stop. The petitioner may apply for regular bail afresh after a period of 12 months and subject to fully complying with the orders passed in the insolvency proceedings. Stop. It is directed that the passport of the petitioner is not to be released by the trial court without the leave of this court.